Hi everyone and welcome back. I'm Jay, the principal migration lawyer here at Flow Migration Law. The last few days of a visa can be an incredibly pressured time. But what happens when your best laid plans collapses at the last minute and a seemingly logical step leads you into a legal maze? Today, I'm sharing a real-life case study about a client who unintentionally became an unlawful non-citizen. We're going to explore the two very significant hurdles she then faced: a potential 3-year ban from Australia and the notoriously difficult Schedule 3 requirements. This is the story of how we navigated a path for her in order for her to remain in Australia and secure a partner visa. So let me set the scene. Our client, a South Korean citizen, had built her life here. After 2 years on working holiday visas, she met her Australian partner and they were in a committed de facto relationship. Their plan was for her Australian employer to sponsor her on a subclass 4A2 visa. Everything was moving along. However, just days before her working holiday visa was just about to expire, the employer unexpectedly pulled out. This left her with almost no time and no clear path forward. In a state of panic and without any professional guidance, she did what many people would think is the sensible thing. She called the Department of Home Affairs for help. Based on the information she gave, she was advised to apply for a bridging visa E or BVE. Now, her first BVE was applied for and granted just after her working holiday visa expired. But 2 months wasn't enough time to sort everything out. That BVE expired, and for about 2 weeks, she was in Australia without any visa. Realizing this, she contacted the department again and was granted a second bridging visa E. While she had a visa again, these actions unknowingly put her in a very difficult situation. At this point, our client was facing two major legal problems. Problem 1, the 3-year re-entry ban. This is also known as PIC 4014. If she chose to leave Australia, she would likely be subject to a 3-year ban on returning. The critical issue was that while her first BVE was granted within the 28-day grace period after her visa expired, her second BVE was granted well after that period. This meant if she left the country, the ban would almost certainly apply. Problem 2, the onshore hurdle. This is the Schedule 3 criteria. If she chose to stay in Australia and apply for an onshore A20 partner visa to avoid the ban, she'd face this massive challenge. Because she had been unlawful before getting her second BVE, she couldn't meet the standard partner visa requirements. Her only option would be to get a Schedule 3 waiver. As we've discussed before, this is notoriously difficult. A genuine relationship isn't enough, and you must show compelling reasons affecting the Australian sponsor. This was the critical moment when the client came to us for help. She was shocked to learn the true legal implications of the steps she had taken. She believed that by following the department's directions, she was doing the right thing. And this highlights a critical point. The department's role is to process applications and provide general information. Their staff can't give you personalized legal advice for your long-term migration goals. The advice to get a BVE, while technically correct to fix her immediate status, didn't account for the severe downstream consequences. After a thorough assessment, we looked at both paths. While the Schedule 3 waiver presented a very high bar, we identified that the circumstances of her relationship with her Australian partner were pretty significant. We believe a powerful submission could be built around the compelling reasons in a case. After we discussed the risks of each option, the client decided to apply onshore and have us prepare a comprehensive Schedule 3 submission. We worked very closely with the couple to gather extensive evidence and to articulate the compelling nature of their circumstances. And the result was a success. The department accepted our submissions. They waived the Schedule 3 criteria and our client was granted her onshore partner visa. She could finally move on from this incredibly difficult period of uncertainty and properly begin her life in Australia with her partner. So how could this situation have been avoided? The key is always to seek professional legal advice before a visa expires. In her case, An alternative might have been to depart Australia before her working holiday visa expired and then return lawfully to apply onshore, avoiding both of these major problems. And what if her case wasn't compelling enough for a waiver? Our advice would have changed. We likely would have told her an offshore partner visa was the necessary route. And while she'd face the 3-year ban under PIC 4410, a partner visa is one of the few visas that can be granted despite this particular ban, allowing her to eventually return. The strategy then becomes about managing a long period of separation. This case clearly shows how one small issue can cascade into major legal issues. Australian migration law is incredibly complex. If your visa is nearing expiry, it is vital to get guidance from an Australian immigration lawyer immediately. Working with a legal professional ensures your strategy is tailored to your ultimate goal. Navigating complex issues like PIC 4410 and Schedule 3 waivers requires a deep understanding of the migration law. With over 8 years of dedicated experience in Australian migration law, as the principal lawyer here, I've handled numerous applications with these exact complexities. This background allows us to develop pathways that lead to successful outcomes. If you're in a difficult situation, reach out to me directly by emailing js@flowmigrationlaw.com.au. Thank you for watching. See you next time.